to order. So at this time, I would like Dr. Ferguson to lead us in the pledge and Reverend McCoy to lead us in the prayer. Please stand.
Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And we do have two committee members who are not here today, Reverend Ben Hackler and also Charlie Wright could not be here today. All right, so do I have a motion and a second to approve this agenda?
I also move that we approve this agenda.
Thank you, Ms. May. Thank you. All right, all in favor?
Aye.
All opposed? Motion carries. I want to remind committee members to speak into their mics as we discuss the new policies and proposed changes for approval at the next board meeting. In accordance with board policy, we will be using cards for any public comment. Do we have any cards? No? Okay. All right, so do I have a motion and a second to approve minutes from the September 4th Policy Review Committee meeting?
So move.
Thank you.
Second.
Okay, all in favor?
Aye.
All opposed? Motion carries. The first two policies that we are reviewing are policy BCBB, notification of school board meetings, and policy BCBJ, broadcasting and taping of school board meetings. Dr. Ferguson will provide a short description of the proposed policies.
Good afternoon. The first two policies have to do with broadcasting our school board meetings, and I see Mr. Miller is here in the audience if he would like to add to this. The first policy, BCBB, says that we must not only give the date and time and place of the meetings, but how it can be accessed to locate the live broadcasting, which we do already. The second policy is BCBG. And again, this is to make sure that our broadcasts are available live.
Okay, so any discussion from the committee? And we have no cards. So do I have a motion and a second to approve recommended changes?
I also move that we approve the recommended changes.
Okay, thank you. Do I have a second? All in favor?
Aye.
All opposed? Motion carries. The next three policies that we're reviewing together are policy CBD, employment of the superintendent, policy FEA, architectural and engineering services, and policy GAK, personnel records. Dr. Ferguson?
Okay, the first one is employment of the superintendent, policy CBD. The only change is in the second paragraph that states such contract shall provide that the superintendent is subject to a performance evaluation by the school board. Just like teachers are evaluated based on their performance, the superintendent would also be evaluated using a similar system. The second policy, FEA, and I know Ms. Mikas is in the audience. This is also a change in the second paragraph. The school board shall negotiate a contract for architectural and engineering professional services at a compensation rate the superintendent determines is fair and reasonable, which, according to Ms. Mikas, we are already doing. And then the third policy, policy GAK, deals with personnel records, and we know all of that is confidential to begin with, but they are now adding that the person's employee's home and personal wireless number their home address, and personal email should also be considered confidential at this point. And this went into effect June 4th of 2024.
Okay, any discussion from the committee? Ashana?
I had a parent to contact me in reference to FEA, and I told her that I would read the question out for her in the meeting, okay? Miss Mendeley was her name, I think. She said, regarding policy FEA, what is the reason for the proposed policy change? Current policy caps total compensation to the engineer or architect at 8% unless approved by the board. Why is the cap being removed? That was the first part of her question.
All right, Ms. Beekes, you want to address that?
Looking at the policy as it is proposed, the cap is not being removed. There's simply a paragraph being added that gives the superintendent authority to negotiate amounts on these contracts. And that, we're already doing. We're already following.
I mean, the cap is mentioned in paragraph 4, and nothing has been stricken.
Right, so I just had a couple of items on this policy in paragraph 3, some wording, which actually does include the 8%, paragraph 4, and then a part of the last paragraph. So in paragraph 3, where it says, and then submitted to the school board at a regular meeting for approval. So our board approves the architect, but we have not been having the contract itself, but we do have the contract go through a legal review process. So my recommendation would be that the contract, because the superintendent has the authority to negotiate contract, that wording be removed. We also have an accepted pay rate percentage schedule that we follow that is the same schedule that the state uses for these same type of fees, because it's not a flat rate. Larger jobs would have smaller percentages, smaller jobs would have larger percentages. There's like a sliding scale.
I thought it was the reverse.
So,
It says shall not exceed 8%. Would that take that into account?
right, because the sliding scale that we use could exceed 8%. So if you have a very small job and you capped it at 8%, you might not be able to get an architect to take on that job. So the
Right.
scale that we follow is issued by the state. So the smaller jobs have a larger percentage.
Thank you. Ma'am.
The larger jobs, so that prevents, a $20 million job from collecting the same percentage that, say, a $50,000 job, because that would be an astronomical
It would overwhelm
amount.
us.
Yes,
It would overwhelm us.
yes. But we do follow the state guidelines on those fees. And I don't know if the answer would be to put that wording into to policy, saying that we're going to follow the state guidelines, which we're already following.
Okay, so I'm just going to read it to make sure. So the fourth paragraph, the first sentence, we will strike at a regular school board meeting for approval. We'll just leave it at submitted to the school board, period, in that sentence right there. And then in the following sentence, all such contracts shall contain the clause that the total compensation to be paid the architecture engineer shall follow the state guidelines.
Yes.
Is that correct?
Yes. And then,
Are we, in that statement, we would not at any time exceed the 8%?
well, it would depend on what the scale is, because I believe on some of the very small contracts, the scale does exceed 8%. Because some of our contracts that we have to get an architect or an engineer, I mean, we may be talking about a $50,000 project or a $100,000 project, and then asking them to write it up for, $8,000 and then oversee the project as it
this policy says you can go above 8%, which is, I'm assuming, what we already have in the policy
Right.
with board approval. Shall not exceed 8% unless additional fees are approved by the school board.
And then the next paragraph, where it says, "The architect engineer shall, by signing the contract, agrees that any and all disputes under the contract, including disputes with related third parties, do any work related to this contract shall be tried in the proper local district court for the state of Louisiana, and does formally agree not to raise and does waive any," I think that's a misspelling, "any pleas of lack of jurisdiction and/or venue in the event of suit by a party under the contract." So each individual contract may have a little bit difference. Most of our contracts now state that we would go into mitigation and not go to court over any dispute. It's only if it couldn't be settled in mitigation that it would go to court. And that is specified in the individual contracts. Every contract that we have addresses that specifically. And that's the standard architect and engineering contract.
So do we need to change any of that wording in that paragraph?
Do we need to add a statement
Adding
saying
it.
pending attempted mitigation? Or after pending?
I would say the architect engineer shall, by signing the contract, agrees that any and all disputes under the contract be settled.
The way it's settled is in the contract.
Right.
So,
So I think that whole paragraph could be removed, or if we leave it in, that it would lead us back to the contract.
The architect shall be signing by signing.
So as long as we're following the contract, we're okay.
Right.
And that's what that paragraph says. But if they don't follow the contract, then it's going to be disputed.
Well, the paragraph says that the resolution is in court, and that's not the resolution that our contracts. We have, and it's been a while since this policy has been visited, so,
Could not we just simply say, including all disputes related third parties who do any work related to this contract shall be tried proper local district? And that we could settle any disputes prior to going to a local court, a district court. We could do that, and if that did not work, then we would move to a local district court. Did that come across comprehensively?
I think maybe we just add the wording, I get what you're saying, is just to add the wording in there.
I mean, the contracts we use are
To follow
standard
the contract.
architectural contracts that our architect, that the board hires, goes into agreement with the contractor. I forget the name of the oversight agency that does that. So there's a dispute clause within the contract that outlines what is in there. So if we change any of that here in policy, then we're gonna have to make sure any architect we hire has this language to put into the contract. But Regina is right. We typically move to mitigation before we go into litigation.
That's, yeah, right.
Right.
Okay, then could we instate that?
Yes, that's what I'm asking.
Yeah.
So basically, yeah, what you just said.
I would
I like the wording that you just used to,
mitigate prior to litigation.
prior to litigation.
Okay.
And then the last item that I have is in the last paragraph. It says, additionally, the architect engineer shall furnish the record set in a digital format approved by the board on a 3.5-inch diskette or a CD-ROM disc and one clear, sharp, legible copy. I don't know that we have anything that would read a 3.5-inch diskette anymore, but I would recommend
So
to,
can we just leave it a digital format?
additionally, the architect engineer shall furnish the record set in a digital format and one clear, sharp, legible copy.
So we're gonna strike approve, or on a 3.5
Just,
Yeah.
or
disc
CD-ROM
or
disc?
CD-ROM.
Yes. Because they do provide us a digital copy, just not on a 3.5-inch diskette.
Good catch there, good catch there.
And that's all I have on that.
Thank you, Ms. Meekus. Any further discussion?
Just for the committee's sake, we are doing most of this anyway. CBD referring to the employment of the superintendent, we already have an evaluation that we've been doing for some time. And then the personnel records, I think, requests grew out of so many public records requests that we receive wanting personal cell phone numbers of our employees and addresses, and I'm glad they made that change. Because we really had no protection to not give that out, so someone wouldn't be constantly harassed by whomever, so that's where that came from.
Okay, Ashana, did you have any other questions?
Piece to her question. She states, how are the architects and engineers selected? And why do these type contracts not go out for bid by public notice, giving one person, in this case, the superintendent, the authority to deem what is fair and reasonable lacks accountability?
Okay, so the architects and engineers are not selected by the superintendent, they're selected by the board. And we do follow the state law. It is a service and we're not required to go out for bid. But we do use a fairly competitive process. I think you see, we use several architects that are in the parish, so they're all competing for every project that we have. But we do follow state law on that.
Thank you.
Okay, any other discussion? All right, so do I have a motion and a second to approve the recommended changes?
A motion to approve the recommended changes.
Thank you, Ms. Biggs. Do I have a second?
Second?
Thank you, Ms. May. All in favor?
Ah,
All opposed? Motion carries. The next policy that we are reviewing is policy GAMK, use of pronouns and given names. Dr. Ferguson?
Okay, this is a brand-new policy that is based on Act 680 that was effective August the 1st of 2024. It's, like I said, a brand-new policy for the state and for our local district. It says, this policy provides for an inquiry of an employee's pronouns that is consistent with the employee's sex, or provides for an inquiry of an employee's name other than the employee's legal name. School boards are also forbid from adopting a policy that provides for an inquiry of a student's pronouns that is inconsistent with the student's sex. Employees, and this is probably the biggest thing, is employees shall not be required to address the student by any name other than the student's legal name, and is required to use a pronoun that is inconsistent with the student's sex. So we have to go by what is on the birth certificate. And again, that's state law. It went into effect August 1st.
Okay, so any discussion from the committee? Okay, do I have a motion and a second to approve recommended changes?
I'll
Thank you.
second.
Thank you, Dr. Ferguson. All in favor? All opposed? Motion carries. The next policy we are reviewing is policy GBC, recruitment. Dr. Ferguson will provide a short description.
Okay, for policy GBC, the change is on page 3 of this policy under criminal history of applicants. Under bullet, or number 1, it basically is now including all service employees as well, those that work in our cafeteria, transportation, janitorial, maintenance, or student services. Anybody that works with any kids, any place, on any school has to go through the criminal history background.
Which we're already doing that.
Okay, so any discussion from the committee?
I think that was just a change, excuse me, I'm sorry, Ms. Nichols. That was just really a change of wording, adding that student, because the actual act went into effect in 2017. So that was just adding that one word.
Okay. All right, do I have a motion and a second to approve recommended changes?
So moved.
Thank you, Reverend McCoy. Do I have a second?
Second.
Thank you, Ms. May. All in favor?
Uh,
All opposed? Motion carries. The next policy we are reviewing is policy IDBA, sex education. Dr. Ferguson?
Okay, policy IDBA regarding sex education, if you'll look at page 1, the bottom of that page. No teacher, school employee, or other presenter at a school shall engage in the following discussions with students in grades kindergarten through 12th grade, so any age. They are not allowed to cover the topics of sexual orientation or gender identity. Number 2, they are not allowed to cover the topics of sexual orientation or gender identity during extracurricular extracurricular, academic, athletic, or social activity. And number 3, discussing his or her own sexual orientation or gender identity. So all 3 of those are new to this policy.
Okay, do we have any discussion from the committee?
Could pre-K be included, or it says K through 12, but a lot of our schools have pre-K?
Yes.
Would that be included?
It would be that,
Okay,
the K through 12 would be what's in the law.
okay.
So we can go above and beyond the law if y'all want to make that recommendation to the board.
I would, as a, having pre-K students, and I don't have the issue, but I think it would cover us.
If anything happened,
Yeah.
Okay. All right, so we're going to add that to it,
I
add
make a
pre-K.
motion that we make that one change to this particular policy.
Okay. Does anyone have a second? Okay, all in favor? All opposed? Motion carries. The next policy we're reviewing is policy IDDF, education of students with disabilities. Dr. Ferguson?
Okay, I'm glad Dr. Autry is in the audience today. This one is on page 1, notification of individual rights. Correct me if I'm wrong. This has to do with the transfer of legal documents once the students turn 18 years of age. And it is the process, you have to notify them at the IEP meeting of the school year. The document shall be provided to the parent, legal guardian, or tutor of each child, starting when they are 14, 15, 16, and 17 years of age, to provide this information to them. So is this something you're already doing? Perfect.
Okay, any discussion from the committee? All right, do I have a motion and a second to approve the recommended changes?
I
Also-
move it.
Go ahead,
I move to approve the recommended changes.
All right, thank you, Ms.
and
Biggs.
I'll second it.
Thank you, Ms. May. All in favor?
Aye.
All opposed? Motion carries. The next policy that we're reviewing is policy JGC, Student Health Services. Dr. Ferguson?
I feel like we've gone over this one a few times recently. The only change to policy JGC with Student Health Services is actually on page 4 of this policy, and it regards sickle cell disease training. Each school nurse shall participate in an in-service training program of at least 1 hour relative to sickle cell disease, including the instructional materials provided by the Louisiana Sickle Cell Commission to the State Department of Education. That is the only change in this policy this time.
Okay, do we have any discussion from the committee? And Orlando, do you have anything to add? Okay. All right, so do I have a motion and a second to approve recommended changes?
I make a motion, we approve the change.
Okay. All right, all in favor?
Aye.
All opposed? Motion carries. Do we have any other comments from committee members? The next PRC meeting will tentatively be held at a date to be determined. So thank you so much for your time serving on our policy review committee, and this